So a lot of the franchise relationships information that we talked about last time, if you were involved in that, you would find that there are both federal and state laws that govern some of that, those transactions. So you want to become familiar with those in the event that your client comes in with a franchise agreement and asks you not to bust up the deal, but to give them advice as to what to do. And the advice they're looking for isn't to run away. They want to figure out how to make it work. The rest of Section 3 that we have to do really deals with a little more franchises in the last case, Zapata, but the next case is again one of my favorite cases. It's the Anthony Pierre case. And there's an awful lot going on in this, so it's going to take a little bit to get through it. But again, I expected you have obviously read it already. It talks about after a jury waived trial. And my guess is, at least in theory, that probably sounds odd to you. Because there's a natural tendency to think, oh, I'm always going to take that jury. There's actually a lot of cases where you may not want to do that at all. You know, and not just criminal cases or civil cases. Part of it depends on the judge you've got. Part of it depends on the length of the trial. And that's an assessment that's probably made much closer to trial. So you want to preserve your rights to a jury trial by claiming it early. But it's not automatic necessarily that you're going to do better with the jury. And with some experience and some thought, depending on the judge, that is not an unwise thing to, at times, is to try the case directly to a jury. Much of this case also revolves around 93A, consumer protection, protection again from fraudulent and deceptive trade practices. 93A does not provide a right to a jury trial since it's a modern statutory remedy. There are a number of judges, though, that would impanel what we call an advisory jury under those circumstances, since there's usually multiple claims that are advanced at the same time, and allow the jury at least to consider and make recommendations, even though they are not the final arbiter on 93A violations. But let's talk a little bit about this case, because there's an awful lot going on, and you read the case. I wonder, first of all, would you all take this case if Anthony came to you and said, here's a bundle of money, I want you to break the agreement, and you read the case. Why does he want to break the agreement?
He thinks he's not getting enough money.
He thinks he's not getting enough money, right? Really, virtually nothing to do with anything else. So he gives you the agreement, and he says, find a way out. And the other thing he gives you is a huge pile of cash that he slides over the table. Anyone sliding it back? No one? So you are the deal breakers I was thinking about last time, right? I mean, because that's all you're doing it for is for money. This whole BS about I'm not quite sure I like the look of it and all, you don't have much of a leg to stand on, right? Right? He's told you, and you know from looking at the evidence, his only problem is he wishes he had made a better business deal, right? I'd rather look at nothing than get a stinking $750,000 a year. Back when $750K was going to be real money, right? We're talking the 80s. So no one's going to tell Anthony, listen, you made a deal, honor it.
We have to take a serious look at it, you know, and do some research and see if there's something in the deal that, you know, is unconscionable, or is it now unconscionable based on current numbers of what they're getting for waterfront property? I mean,
but they're both business
This
people.
Reminded me of the pigs get slaughtered.
Well, I hope so. I mean, I think.
You know,
I think
was
this
glad
is
to see them lose, and they sent it back for the 93A.
Well, but you lost too, though.
Right.
Right. You were his lawyer. Those of you that said, okay, Anthony, I'll represent you, because I found a way out here. Right. I mean, that's what you're hired to do. Right. He gave you the agreement. He doesn't know where the way out is. you read the agreement, you went over it like a first-year law student and said, did you ever give him in writing that it was acceptable to you? Right? And he says, no, never. So, ha! We got our way out, right? I mean, that's, the deal's the deal, and if it's not there, we're going forward. Right? Well, that's your job. You're the lawyer. No one's going to have a heart-to-heart, come to Jesus, talk with Anthony, and say, you know, you really think this is the right thing to do? You made a deal. Deal at the time you were satisfied with. You're satisfied. You appear to be satisfied with what the development looked like. Shouldn't you do the right thing here? Go ahead.
Well, there's a different way of looking at it, I believe. Like, yes, he made the deal in the beginning, but what if when he started work, he really felt that he deserves to be paid more? What if they're asking him to do things that initially, maybe it was like just, you know, verbally they contracted to do certain stuff, and then more was asked of him. Maybe he does feel like he deserves more.
But you're adding facts that we don't have anywhere within the case, because that's not a bad argument, but none of that is in here, right? No, right. What changed was the economics of the deal. Is he thought at some point he had seller's remorse, right? It happens, and he thought I could have got more. We always could get a little more, right? We always could pay a little less. I mean, that's the nature of no matter what deal we're in. So, I mean, this I'm going to call it, it's greed, isn't it? Does anyone disagree? Or no, it's okay if you don't, or it's okay if you do. No, Professor, I don't mind representing the greedy guy. He's got money. He's got a legal basis, I think. What the hell? I didn't go to divinity school. I went to law. No, right? That's what you're all looking at me like. And listen, let's be honest. This isn't a little bit of money. This is real money. This is one of the most influential people in Boston, both financially and politically. And that's the other thing. You make this case. You win for him on a tough case to win. Your bones are made. You're a big deal in this city, and he owes you, right? So this isn't just about all the money he's going to give you, right? Good lawyers should win the winning cases. Great lawyers win the ones they're not supposed to win. So so you're all in. You're all in, right? So no one.
Will the personalities come into it?
Huh? Well,
does Anthony's personality?
You know him? I mean, do you?
Well, I know.
Okay, yeah, right. Well, but I think you get a flavor for the personality here, right? I mean, I have no doubt he said precisely what it's described. He said, and probably would be prepared to defend it, right? No, yeah, this is mostly about money, and it is. Listen, and it's big business deals are oftentimes a lot about money. Let's not fool ourselves about that. Is there anything you're going to do? Because I mean, when you talk to Anthony, and we talk about. I mean, that's my question. You guys think we can win? You think we can win? No? Okay, that's what you're going to tell me, Anthony. I don't think you can win. I'll take your money. I'll do what I can. I'll try. I'll give it an A1 effort. And we're going to spend a lot of money before we get to the end of this game. But are you going to say, I don't think you can win? Are you going to have that conversation? I'm still not seeing that many heads shake their head. Yes, that better be a conversation we have here.
Well, I think you need to be upfront with any client that comes into your office. They are coming to you because you're a professional, you're well versed in the law. You need to basically lay it all down to them and say, listen, this is the reality you're facing. Yes, in your mind you think you have the greatest case in the world, but these are the merits and these are the facts of these cases.
Let's be honest. Even he knows he doesn't have the greatest case in the world, right? He's just looking for one of you weaselly little lawyers to get him out of his deal. No, right? This is the type of thing that the reason people hate us, isn't it? You don't really have a good argument, but you have a legal argument, and you're gonna drive a truck through it if you can, right? I mean, am I mischaracterizing? You guys can say, Professor, I think you've got it all wrong. I mean, you're taking a technical mistake, technical omission, and you're using it to blow up a hundreds of millions of dollar deal, right? Again, have I mischaracterized anything?
Things come in small packages.
Huh?
I'd feel bad about it, but
So that makes you feel better. Yeah. I feel bad about it, but this is my job. This is what I've been paid to do. And so Ray, so that disclosure tells him what? I mean, because I quibbled with you, said, well, you might have the greatest case in the world. We're not going to even say that, right? You don't have the greatest case in the world, Anthony. You might have a legal basis to go forward, and we might win. Because that's the best it gets, right? You can't be telling him he's got the greatest case. I mean, you already know the end result here, too. So what are you going to tell him? Because he may well tell you, I don't care. I want my land back, or I want a significantly better deal, and I will drag them in and out of court forever until I get that. That's
Well, if that's the
But-
case, take it. I mean.
no, but take it. But
if he-
that.
If he is informed as by you telling him all the merits of the case.
Well,
and if
wait a
he
minute.
comes up and
Did
says-
you tell him that? Did you tell? That's what I want to know. Did you say, okay, listen, I'll take the case, but this could go really, really, really bad?
And if he says.
No. Did you tell? Did you guys all tell him that?
Yeah.
You did. When you wanted that 50 grand, he was pushing on this side of the table. You said, okay, listen, I'll take that. But let me be up front. Let me be up front about what this looks like. Did you have that conversation, or did you want the 50 G's? Too bad that I'm not sure we can win. We've got a shot here, but realistically, you're pushing a big rock up a hill. You should know that. Did you at least say that? But we got a chance, right? What do you say?
There's always a chance.
There's always a chance. So that's always a chance. Did you do any of this in writing, or did you just talk to him? Right. So in writing, what did you say, Steph? You said what? Give me just a couple sentences so I get the feel.
I would just I don't know if I would write exactly what you said, that, there is maybe a small chance that this could come out on your end, but what I'm looking at right now, before doing like the due diligence and little investigation that I can, you need to understand this, and I need you to acknowledge this, because then if he doesn't like the judgment that comes
Acknowledge
out,
what? That we could lose
that we
and lose
discussed this,
significant.
and that we could lose, and that there's a chance that we could lose significantly. He could come out with nothing at all. And I would write it down so that in the end, if there was ever to be a malpractice claim, or he ever made a claim to the BBO, I could say I addressed the situation with my client, and I talked to him, and he understood and gave his informed consent.
Well, so you all doing that? What's this shaking your head at, maybe?
I would say yes.
Go ahead, yes?
Yes, because then he could come after me if he's.
Oh yeah, because, let me ask this even from a standpoint of not just simply covering your butt. Don't you owe that to him as a client? Don't you owe him a real assessment and let him know what his legal risks are here? Listen, as I said, a guy like this, he may want to go forward anyway. And I do think, though, your job is to make sure he's going forward on an informed basis. Because he doesn't necessarily, can't see the entire playing field, but that's the reason you went to law school, is so that you can sit and look at something like this and say, okay, we've got a legal argument. And I know in law school sometimes that seems like, well, that's going to trump everything. It's not always. It's not always. The judge is going to look at your client, he's going to look at the facts. And I think, like lawyers do, judges come at it from the back end. Okay, listen, I want him to win. I'm going to tell my clerk, I want him to win. I think he should. I think that's the just thing. You go find me case law that says he should win. I mean, that's what we do as lawyers, right? I've got a client. I have to advocate for them and see that they win. Now I have to go out and find the case law that supports why we win. That's what we do, right? And we find other case law, we can distinguish it, sometimes blink it away, and sometimes make it believe it doesn't exist. But we're using the case law that supports us, because it's always shades of gray. I wouldn't be so naive to think that that's not the way it works from a judge's end as well. That the judge will tell his or her clerk, And sometimes you can't overcome what the law actually is, and the side that you don't want to win has to win. But I'm not so sure more often than not, it's not, these people need to win. I need to find a reason in case law that supports why they should win. And so he doesn't look all that, well, certainly not benevolent, and he's not that nice, and it is pretty greedy, right? You know, and both of these sides actually have plenty of money, so you don't have to worry about who's going to be paying the bills and who might look greedier, because they both have tons of money. So we think we're going to tell them in writing that there are problems with this case, which again is a delicate thing to do because you would like this case. I would like this case. I'm not sure I'd like representing him, especially now we know how this all turns out, which isn't well. Right? Go ahead.
I think the bottom line is, if you know the case is a loser, then you don't take the case. If you think you
Well, is that
might
true,
be
though?
able to win it, then you inform him, hey, there's a chance we could win, but there's a high risk that we're not going to. And
Let me back up because I want to question the first assumption. Would you defend even if you knew it was a loser? I mean, defendant should get a defense.
I wouldn't file a complaint if I knew it was based on faulty grounds. I mean, or
Okay, but that's
if it was-
I want to make an assessment on that. Knew it was on faulty grounds, or knew you were going to lose.
I
I'm
don't
not
know
trying
that
to
you
be
can
pedantic,
ever know that
but
you're
what
gonna
does
lose.
what does that mean? When you say I know I'm going to lose?
If you know there's no merit to the,
No merit, zero.
well, if you look at it and say, you have a contract, and, you know, it would be, I wouldn't be doing due diligence to represent you in this because all the elements of the deal are met. You know, I would
But
say.
except for that, what these guys over here tell me is a very significant sign-off that doesn't exist. It
But
doesn't
if I think,
exist.
if I say, okay, listen, the acceptance, we can fight.
You can manifest
we
it. You
can
manifest
fight
it in other ways.
acceptance, okay? It looks like you manifested it through being on the brochure and, you know, or displaying you in, you know,
Video.
in the display,
Video,
and,
that's-
you know, whatever it was, and, you know, the many ways that he displayed that he had accepted the deal, other than a few minor things like a parking garage or a bridge or a footbridge, which are probably ancillary to the actual deal itself. You know, if you really think there's no chance of him winning, I don't
But
think.
is that what it is? No chance? Because that's I really would like you to think about pinning that down a little bit. What is it? The case you take versus the case you send away. Is that the difference? There is no chance. And at the end of the day, I think there's no chance, right?
Right.
And you've been wrong before, right? No, right? We all have.
Right.
What are you going to say to me?
Go ahead. Just that juries and the outcome of a case are always unpredictable.
Never know. You never know. You're going to win some, you should absolutely lose.
Yeah.
And you're going to lose some, you should win, right? That's the nature of it. So which ones do we turn away? Really, is the standard 0 chance? 1%, 2%, 5%? I mean, if we were to assess it before, we know the outcome of this. He comes in, you see it, you say, geez, there is no sign-off. That's pretty significant on a project of this sort. Someone should have dotted their I's and crossed their T's. What would you have given his chances at the outset, even trying to be realistic about it? 5%? 10%? I mean, you must have read in contracts, it's, you know, right, what are they? Preconditions have to be, what are they called? Contingent something or whatever in contracts? I don't know. You guys study contracts far more recently than I did. Conditions precedent, they have to be met before the contract's enforceable, something along those lines?
Yeah.
I mean, it's pretty big significant that precedent that there is no formal sign-off for what should have taken place. I mean, I don't have to do the lawyer on the other side's job either. They want a deal, they should have made sure they got it. So, I mean, what would you have said his chances of success at the outset were after you reviewed the agreement, looked at,
50-50.
50-50, wow. So you're not even going to send him that CYA letter. Contemplating, gee.
I'm looking at this case going, even if it's found there was no valid contract, promissory estoppel is probably going to prevail.
Well,
You know?
and right, there are various problems
There's
with
so
this.
much, there's so many years of them moving forward and agreeing on so many things that, and so much money invested. I mean, I would think that they could find there was no valid contract, but still, you know, still find promissory estoppel. I mean, I'm not sure how it works in the real world.
No.
but, you know.
That is how it would work, and that's the problem. That goes back to the point about when the judge decides, I think he's going to win. Figure out how. That's where we start to look at the various theories. The cases you take, though, I want to go back to Fred's point. No chance of success. Okay, that's easy. Hopeless, hopeless, hopeless. Get out. Right? Those are easy. But how much further up the ladder do we have to go till we say, okay, I'll take it. It's a long shot, but I think you have a chance. I think the case says, when we say, and that's what I guess I'm trying to ask you about. When we say the case is sufficiently meritorious that we're going to bring it, what does that mean, sufficiently meritorious? Does it just simply mean not hopeless, or 5% chance, 10% chance, 20% chance?
Rule 11.
I think I'm going to win. I mean, and that's the other part, right? My best objective assessment is we should win. Okay, that's easy too, right? Well, that's a case that, assuming the evidence supports it, and that's the other part, right? It's not just your objective assessment, what you think. You need to look at the stuff and make a real objective assessment. I think we should win. Okay, that's easy. No one should quarrel on that with respect to Rule 11. There's a whole bunch between hopelessly not a chance of, and we will lose, versus I think we'll win. Where is that you can comfortably say, okay, I can go forward with this? Because the client deserves a lawyer, and I mean, 10%? 20?
I think it's hard to put it at a percentage,
Yeah.
but just like if the legal basis, if you have a strong legal basis to support.
But what's strong mean? I agree with you. We don't need a percentage. I just want you to better define the cases you're going to advance. Because you're all taking this one, and you all know how this one turns out, right? So I might have guessed that some of you might have said, no, I think I'm going to pass on this, because as you already recognized, at the end of the day, and I'll skip to the end, I would have asked you at the
You
end.
know what?
If I'm Anthony now, and I look at these numbers, I'm going to go find another lawyer and say, did my first lawyer do me justice
Well, that's
here by
another-
telling me we had a case?
That's
Or
another
can I sue
point,
them?
though. When you're a lawyer at this level, maybe you don't take, maybe that kind of money isn't as important as your reputation, because, I mean, this isn't a guy that just graduated from law school that he's going to, you know, I mean, like us. We're talking an accomplished attorney or firm who, you know, in some instances, the 50 grand that he pushes across the table as a retainer really isn't as big a deal as it would be to, you know, one of us.
Except, in fairness, to fuel that type of practice, to fuel that little empire, there's got to be a whole bunch of people pushing 50 grand across the table every week, right? So, and especially a client of this size with development rights like this, don't be so sure that they're not just as captured as someone who pushes a big pile of money to you as the solo practitioner. Frankly, my experience is with the larger firms is they are far more likely to do unethical and improper things than the solo practitioners or the smaller firms, simply because they can hide behind the big firm, and they do. You know, if I give you my word that this is the way we're going to do something, then that's the way it's got to be. Otherwise, people are going to say you can't trust him. And I'm afraid that that's my experience is that the abuses come from the bigger firms to a greater extent, and when they do, they're real big abuses. I mean, you know, the fact is here is that this isn't just 50. The likelihood this was a millions of dollar fee case before we're done here.
Would you have taken it?
Huh?
Would you have taken it?
I don't know. I mean, in hindsight, and that's right.
No,
Sitting
no,
here as a
yeah.
professor, it's one thing. If Anthony comes into my office, and with this type of case, I mean, you know who HBC is too, right? I mean, that's the Pritzker family of Chicago. You're not playing in the minors anymore. You're playing in Fast Pitch League, and if you can do something here, you don't have to worry about what you're going to be doing after this, because you're going to be getting tons of clients. So I don't know. Huh?
Either way, that's true. Win or lose.
Nah, you lose hundreds of millions of dollar cases, and they tend to say,
That's it.
why did he pull the plugger? There's a whole bunch of things they say.
Where do you get your limit?
Well, that's the other thing. You lose for him, and he could blackball you too. So let's, I don't know yet, because I have to think more about it too as I see it, because I really do need to think, and I think we need to think. So, suppose I would peg his chances at the outset 10%, 1 in 10. Does that mean he doesn't get that means he doesn't get me, or doesn't get you? Even assuming it's that low, 1 out of 10. I know he'd get you. Go ahead.
I guess if I was a really confident lawyer, then I'm going to take someone that I think I'm good enough to take their case.
Right.
And if I'm not, then I'm going to say that up front before I get sued for malpractice. I'm not capable of doing this. Whether it's 10% or 50% winning, if I think I cannot win your case, I'm not going to take it. If I think you stand a chance of me helping you win, whether your chances are slim or not, you said there are great lawyers that win cases they shouldn't win.
Yep.
If I'm that great lawyer, then I'm going to take your case even if you likely would be losing, because I think I'm going to win it.
Well, is that true though? I think you got a 1 in 10 chance of winning. I think I can win it. I'm not sure I will. Can I still take it?
Yeah.
Because what you said is I've got a objectively I've got a 1 in 10 chance. No, actually, objectively, the rest of you would have a 1 in 10 chance. But me, the great lawyer Geneva, I have a greater than 50% chance of winning this case. Right? That is what you said. I think.
No, I'm saying if I'm one of those lawyers, if I'm winning cases left and right that I know in my heart I shouldn't be winning, like, oh my gosh, that
It won't be left and right. You don't win.
No.
Hopefully you'll win more than you lose, but you will win cases
Right. If I
that
have
you should.
experience that I think I'm capable of winning a case that someone next to me is probably not capable of winning, then I would take it. If I'm the person that I can recognize in myself, I do not have the experience to be taking that case. Even if like say I was coming right out of law school, I would never take one, even if it was 50%, because I'd be like, oh, I don't have that much experience. You know, you probably.
You gotta try one sooner. You gotta do the first one sooner or later.
Right, but I want one that has a good chance of me not messing up.
Well, that's the loser,
Yeah.
right? No, I mean, see you guys are going the other route. Try a few losers. I've told some of you the story. I lost my first case before I even got to do the closing argument. I said, Judge, I haven't done my closing. Just a small case. He said, Judge, he said, I find for the defendant. I said, Judge, I haven't got a chance to do my closing argument. It was a couple-hour case. It wasn't long. He said, okay, go ahead and do it. Done. Didn't turn the tide either. So take the losers. Try those, right? I mean, and by the way, what, do you really think they're giving you the Anthony Pierre the first day out of law school? Because that's not happening either, right? You're going to have to carry some bags before that happens. So go ahead, Laura.
I just say, as long as you're honest with the client, tell them what you think you can do for them, and then it's in their court. If they want to take a chance, go for it. I mean, as long as you're honest at the outset, then if you don't have that much of a chance, you tell them, and they're into it, then go for it.
See, I think, and I do think that that's right. And let me just ask you one other question and further into that with this. Okay, listen. We may not win in trial, but between day one and trial, we got 18 months to 2 years. Maybe we can get some leverage along the way, and maybe we can win a few motions so that we can get him the better deal he wants. I mean, trial isn't necessarily what he wants. What he wants is a better deal. And so, is it okay to use the litigation process for leverage?
Yeah.
We'll beat them up, we'll run them around, throw a little paper on them, do a bunch of depositions, start cha-ching, running up the bill. Sooner or later, and seriously, like this case especially, sooner or later, someone should have got together and said, okay, let's see if we can put this deal back together before the lawyers all get rich and we're just mired in a mess. I mean, is that okay?
I was going to say, it's not okay. There's other considerations, like it's not okay if you don't like your clients and you don't believe in their case and you can't work with them. So I think there are some limits.
John, do you believe in his case? Because all of you said you'd take it. And that's my question. Do you like him? I'll ask your questions. Do you like him? And the second question is, do you believe in his case? you raise the question, then I'll come over. Do you, what's
Well,
your?
he's gonna go, I would think the option of, I don't know, that's a good question.
No, well, you guys, I mean, because here's the other thing, is, I'll be honest, you don't like all your clients, right? I mean, you recognize that, right? You might want to, but the fact is, a couple things about that. You may work for a firm where they just simply assign, you're the assigned lawyer. If you want to keep working here, that's your client. Had that too, right? I think I told you that. I was her 10th lawyer, 10th, okay? Three previous reported to the BPO. Oh, what a train wreck this is coming down the pipe, right? So not only will I get fired, but I'm going to get reported. And this is yours, Mike. I said, great. So it wasn't reported, by the way, but it was a mess of a case before we were done. You don't always have a choice, and you don't always like them, but they're yours, and no matter what, they get the very best of your representation. He's not that likable, right? I mean, this is not the orphans who will be thrown out of their house because Freddie Mac screwed them over on the balloon mortgage and everything else.
I mean, he's not likable, but when it comes to these type of business deals, I mean, it's no holds barred. HBC would screw him in a heartbeat. Right. So they're sort of in the same playing field, in the same, level of money and arrogance. So,
Scorched earth, right? Anything goes.
I mean,
roll up our sleeves, let's wrestle in the mud.
I mean, not anything goes. You hope to get the guy a better deal, but when you're looking at this guy who's arrogant, it's not like the other side's a sweetheart either. I mean,
I'll come back, Freddie, because you had your hand up and I didn't get you.
I did. So two things. First of all, I would not take him.
Oh, you would have sent him back?
Yeah, I would have just straight up turned him down. But going back to the issue about waiving the jury, I mean, it almost feels like one of those cases that wouldn't stand a chance if you just went to argue in front of a judge. But if you had a jury, depending on how you argued it and who they liked the least of the two,
well, and it might be an interesting question as to why they waived and why not, because again, the unpredictability of it, where a judge might see through some of it a lot more easily. It's a fair point. Right.
If it was locally, I think they would have had a better chance, possibly, for a jury trial. I mean, if he's local, Anthony Athanas is a local guy. I mean, he's got property all up and down the North Shore. But I mean, I think he might have some buddies though, someone that may feel akin to his plea if in the jury.
In the jury, maybe why he chose to waive jury. I mean, he's when we get to the end of the story, you'll see how connected he actually is. But I mean, fundraisers, you name it. Anthony knew how to play the game extensively, and did. So maybe he felt that for whatever reason he would have a slightly better chance in front of the single entity. I mean, we're not sure what the analysis was. As it turned out, if that was his analysis, he was dead wrong. Go ahead, Fred.
The other thing we don't really know from the facts are how much did the value of that property change over the course of those years. It could be to the point where it makes the prior deal unconscionable. I mean,
well, is it unconscionable simply because you don't like the number anymore? Yeah. Right? Is that what makes it unconscionable? What, guess?
Yeah,
is that what you said? Yeah.
Yeah. I mean, I don't know what else to say besides look, but let's say real estate, because there was a period of time where real estate went from maybe it was worth $1 million to
at the
now
start
it's worth
this wasn't even parking lots because people wouldn't even park down there back at that point.
But so I'm not sure in this time frame what happened to waterfront property values, but they talk about other projects going on that were, better deals. So waterfront property is now worth more. Now, do I think he's a greedy asshole? Basically, yeah. But is it possible that the deal is so bad that I would want to, represent him? Yeah. I mean, maybe there is some merit to this is a horrible deal now.
But a deal's a deal.
I agree. I mean, I think he's greedy, and the case made me never want to go to another restaurant that the guy owns, or I mean, literally, in the Sun's comments, I'd rather look out at nothing than a bad deal. I mean, that just makes him all sound very arrogant,
Oh, yeah.
But I think maybe there is some huge amount of discrepancy in the amount of money that
I think you could assume there is. But I'll go back to but a deal's a deal, no? Right?
Well,
This is
no,
the deal we
no.
made, okay, you don't.
But she made a good point, you
What?
know, in that world, if you've got a really bad deal, then you look for a way to get out of it. I mean,
And
probably
you're the
both
vehicle.
cases arrogant.
And so let's just call the lawyers.
Right.
Right? No, really, right? Just call the lawyers, because that's what they're paid to do.
I mean, as long as you say, listen, the likelihood of success in this case is, you know, low, but here's the argument we can make. It's up to you. The ball's in your court, Anthony. Do you want, you know, I'll make the argument, but it's going to cost you a lot of money and we could lose. You know?
But I'm ready to go.
Well, here's the argument. If you have a legitimate argument that you can make.
And the legitimate argument, just so we're clear, is this technicality
Right.
about no formal sign-off. And that's
As
we're
long
good. As long as he knows,
you know.
I don't think we can win, but I think I can make a lot of money along the way. All right?
Right.
As long as he knows that he could lose. Laura, what were you going to say?
Oh, I was just gonna say to the unconscionability thing.
Go ahead.
Isn't that, doesn't it matter at the time you make the contract, so how is that?
Yeah, right. That's why I think undercuts his.
Maybe it's not a...
The deal's the deal at the time. The fact that 10 years later you don't like doing it because you're not making enough money, that's too bad.
But in that part of life, there's always, like, a deal's not necessarily a deal. Like, for example, I'm a union rep for work, and both sides are constantly renegotiating the deals that we've made. A deal's not necessarily always a deal.
But they're negotiating, right? They're negotiating. They're not using the
But you sign
litigation
up.
process as a hammer
This is-
to make you do something.
I agree, but at the same time, when things change, you go back to the table to renegotiate things that change.
But
So
you,
a
but,
deal's
okay,
not
but,
necessarily a
so
deal.
ask me to renegotiate this deal. Ask me. No, right? I mean, I agree with you, but that's,
I think that, I mean, in this case here, I mean, definitely it seems like Anthony's arrogance hurt himself because HBC obviously really wanted this deal. If he hadn't been such an arrogant ass, as someone said, then maybe they would have talked. And that's where I think maybe the leverage that you get working within the legal realm, that maybe you can
so
get
you're
a
just the
better
levers.
deal. But
We're just putting a little pressure, taking it off. We're just here to serve our client's interests, whatever it is, which is, it's okay.
Sometimes.
Sometimes. And if we can better the deal, even though it's that technicality, well, what the hell? That's the technicality you're referring to, Professor. That's the law. That's what we're schooled in.
But that's a basic tenet of contracts to have both parties sign it. So, I mean, that's in the first year, in an early law school student mind, that would be the hinge, like you said before, that it's not signed, it's not valid.
We're done.
I agree with that. I mean, I don't like him, but I would take it only because, well, for two reasons. I guess people make deals all the time, and sometimes they want to undo them. And I'm thinking about this more in like, say you're a criminal defense lawyer, somebody did something wrong, and they want to undo it sometimes, and you're there to help them kind of undo
Make
it,
it
or
right.
yeah, make it better. So
Make
this
it
is
better. That's right. He's not making it right.
not necessarily right, but better for your client. And this is the same thing. And if you have something to attack here, which is a contract, which is a valid claim technically to go after, then I think you should take it. The only thing he had here is that technicality. If he didn't have that and was just saying, I just want more money, but there was nothing to attack at all, there was no merit to it, then I wouldn't take it.
But let's be realistic. You guys had to go really look hard to find that technicality, because there's a video, right, where he's in glowing praise of what he says now he doesn't like. Correct? And by the way, you can stand there in front of the judge. I mean, what is it? The $4 an hour that allows you to do that? To stand in front of the judge with a straight face and say, you know, he was never satisfied with the project, never signed off on it. Because I'm probably going to queue up the video right after you say it. No, I am, right? Okay. That's the way this works. If you want to do what you're going to do, then I'm going to do what I'm going to do. And so, does that worry you at all, that you're standing there saying, no, Your Honor, he never signed off, was never formally approved, never was sufficiently pleased with the project to give his final okay? I wonder if I could just have a minute. Huh? Right? So how does that work for you guys now? I mean, I know you're getting a lot of money, but You comfortable? Go ahead, John.
It's gonna hurt your reputation in the court with the judge and.
Right, I'm gonna ask you. Well, that's your client, right? That's not akin to signing off to approve, that's not akin to approving the project? And you're really able to say, no, Your Honor? No, I mean, that's what you gotta say, right? No, Your Honor. The contract that was entered into by the parties, both represented by highly experienced and able counsel, required specifically that there be a writing evidencing approval.
You say the video was done in anticipation of an agreement that we never met.
And otherwise.
So
Go ahead.
I would argue that the video was done just for publicity purposes to facilitate the deal.
Also, Anthony's just lying on the tape. So your client, no, Your Honor, he never proved, he's just lying on the tape.
Well, not that he's lying, that he's trying to, encourage his investment, that he truly believed in it, but, the technicality is, and that's how most cases are run on, technicalities.
Well, but wait a minute though. My recollection is, I hear what you say, but my recollection is he was really praising the project on that tape. Am I mistaken?
No, he did, but you could argue that, well, if you're gonna take it and argue it, and you're gonna look like, you're up in front of that, well, yeah, he was doing it because he truly believed at that time, or, that this was being done properly, but however.
Are you able to make, with a straight face, the argument that not all contracts, especially contracts between business people, don't have covenants of good faith and fair dealing in them? Because that's what you did in this case, right? You were arguing, oh, listen, we're business people. We each expect the other to screw. No, right? So that's.
Yeah, all contracts have a covenant.
Oh no, right? No. In this case made it clear. But you advanced the argument in this case that not all contracts have covenants of good faith and fair dealing in them. Specifically, contracts between business people under Massachusetts law do not. That's what you said.
Hey, let's face it. No one in this room would take the case if they didn't think they were going to make a couple million off of it.
Well, you're making right. This is not a free. You're not doing this for free. You get your ears boxed in like this.
No one's taking this case based on principle,
Well, okay, exactly. That's right. So he wants to lay it out even clearer, right? This is not,
this is
a principled decision.
This isn't Aaron Barada.
This is paying off all of those student loans and all the rest of it, right? This is just doing it because you got to pay the bills, right? And you're a lawyer, and he wants you to represent him. There's a bunch of things that I want to ask you about. It says here, at least as early as February 17th, 1987, I think this is page 459, Anthony retained a new law firm. They were retained from the outset to assist Anthony's in its efforts to alter the terms of the original agreements. You see that? That wasn't a heads up to you? That wasn't a heads up that the first attorney said, I'm not going to have any part of this. It's on page 459 of the original decision. I think in the package it might be the mid of 158. That should be a red flag, shouldn't it? The first lawyers walked out of the whole thing. He made a lousy deal. He needed more money. The whole list of issues was really only about money, and he had to get more money to be satisfied. And that his kids were only going to get a lousy $750K a year out of the arrangement. At a meeting the next day, Anthony Athanas declared, "We have no deal." I hope you knew all of that before jumping into this.
Isn't that just that he verbalized it? Neither party's in it for anything other than money. He just said it, which made him look like a jerk.
I agree. Go ahead. Yeah.
No one's faulting the other side for not catching the technicality when they made the contract.
Well, I do think that that's right. That we're laying it pretty heavy on him.
Right.
But the other side had lawyers that this should not have happened.
Right.
You've got no lawyers are covering themselves in glory in this one. There's no doubt about that. there's, you see footnote 15? I want to ask you about that. It's on, mine it's on page 462 and 463. It says, on the same day, you see that? Anthony's conveyed record title and fan pair to the Vineyards Nominee Trust, and Athanas' 4 sons are the trustees of the Vineyards Nominee Trust. So in addition to filing suit to try and break the deal, you also then tried to transfer the property to make it harder to get in the event the deal went bad. Huh? Yeah, that doesn't make it look very good. Would you do that though? No? Why not? I mean, isn't that what we do though? Is in part, we try to prevent the massive exposure to our clients, right? If a doctor came into you and said, I'd like you to make me a PC so that I can't as easily be sued for malpractice, you would do that, I assume. If the doctor said, I want to put my house in trust, or a lawyer said, I want to put my house in trust, you'd do that, right? That's what we do. We're preventive legal advice. Hopefully, that's be better earlier on.
There was a case in the news today, some millionaire or multi-millionaire in Texas adopted his...
Florida. Oh, was it Florida or Texas?
I thought it was...
I thought it was Florida. It could be Texas. It doesn't really matter.
42-year-old girl. He's 48, charged with vehicular homicide and a bunch of other things, and adopts his 42-year-old girlfriend to get access to a trust that his kids only have access to. Oh, yeah.
The lawyer had to think this one up.
But it's a lawyer probably suggested that to him.
There's no way, absolutely. Fred's right. If you heard about it this morning, he's got some significant exposure coming in 2 weeks because of driving under. She actually died?
Yeah,
the person he hit?
Negligent.
So what he's done is he's adopted his 42-year-old girlfriend.
To access some trust.
To access the money. So and that was one of you guys too. And the question they asked, whether they were talking to him on the Today Show, then, so does that mean if he has sex with her, that it's incest?
That's what I was It sounds like he's going to be in jail, or he is.
One way or the other. They said it has to be a blood relative. They said it has to be a blood relative in Florida. So wait a minute. So you guys would take his case, know it's suspect, but you're going to draw the line at now trying to protect the real estate from seizure or attachment at the outset, or no, look, in for a penny, in for a pound, Professor. If we're going to do it, and it's going to be scorched earth till one of us dies, I'm going to erect every barrier along the way, and I'm prepared to defend those decisions. Right? I mean, if you guys have decided to do this, why would you quarrel with this then? Right? You're in it. You have the guy with the black hat. You have the greedy pig, and who's got a thin reed to rest his legal arguments on. No sense leaving any bullets left. If we're in, we're in. No, or you do draw the line here. Because can you tell me why you're drawing the line here? Because I'm not sure I understand that. Is that, I mean, you really do. This wasn't a principled decision of yours to take this case anyway. So now all of a sudden we're saying, oh, but I can't do that. Because I would think if we're going to do it, well then my job is to erect, within the bounds of the law, every barrier I can to the massive potential exposure that exists with the decisions you're making. Not just for you, but for your client.
I think you would have to do it.
So you would
have to. If you're going to go along with it, you're going to have to do it. If there's that small percentage, I mean, otherwise you're not zealously representing your client if you don't offer that. I think in a way.
Unless he flat out tells you, I breached this contract on purpose. Well, then ethically, I can't do it. But
I think he's probably. You have that, don't you?
Yeah.
I breached this contract on purpose. Well, actually, I want to breach the contract.
You're
the one that said this is the way to do it. Right. No, right, because the hypothetical, he brings you the agreement and says, get me out.
That's okay.
There's a difference. Okay. I'm not sure I understand how there's a difference, but we got a lot to do here. So they filed suit. Anthony's and HBC filed suit at the very same time on January 19th, 1988. HBC seeks declaratory relief and damages for breach of contract and breach of the implied covenant of good faith and fair dealing, as we talked about, as well as restitution, specific performance, and general law chapter 93A damages. What's declaratory relief? Because they're both seeking that, and it's a very standard equitable remedy that has existed for ages. What's that? What is declaratory relief? Declaratory judgment.
Would it be like the kind
Would
of
it be like, or is it?
Okay, the court could say that the contract is valid, or that it's not. In that case, in HBC's case, the court could declare that.
That's an example. I'd like definitions first. Ray, what do you got for me? You got something?
Declaratory judgment is essentially a declaration by the court which delineates the rights of each party that's involved in litigation, what the responsibilities are, and who's entitled to what.
Right, to a real or threatened controversy, it is a declaration of the courts, of the parties' rights and obligations to that real or threatened controversy. And here, we have, in fact, both sides seeking declaratory relief, asking for, in essence, what our rights are under the terms of the contract that we signed. It's an equitable remedy, which means you don't have a right to a jury trial in an equitable matter, and they're both seeking that. And then it talks about the covenant of good faith and fair dealing. Talks about restitution. What's restitution? Well, making the parties whole. What is general damages? But under what is restitution? You must have a definition for that somewhere from one of your contracts professors.
In the civil case, the amount of money necessary to restore a party to the party's position prior to the suffering the wrong, sometimes referred to as making the party whole.
Okay, so we're going to make the party whole. Say it again.
The amount of money necessary to restore a party to the party's position prior to suffering the wrong, sometimes referred.
Stop. So to make them whole and put them back in the position they were prior to suffering an injury. So what does that mean? Pre-contract. So what does that mean?
Prior to breach.
So restitution means that, huh? If there had been no. Well, but see, here's the problem with the language. If there had been no breach, because there's two different ways to measure the damages here, right? If there had been no breach, we could give them the profits they would have made, or if there had been no breach, we could look at what they've spent up to that point. So there's two different measures, as we're going to see when we get to the end of it, and they're called different things, right? Reliance and expectation damages, right? So, and so they're both measures of restitution, right? So what's reliance damages?
The amount you relied on with the contract. I can't say.
Yes, you can. Work through it. What's reliance damages?
It's to put you whole to where you would be if the contract had gone through.
Well, that sounds like expectancy damages. Well, let's try that. What's expectancy damages? Think of the language. What you said. What's expectancy damages?
I would say expectancy damages would be what you would get had the contract been completed at the end.
Yeah, right.
Well, reliance would
Right.
be
Think about the
what
profits you would have made. What you expected to make had there been no breach, right? Expectancy damages. That's pretty straightforward. If you think of the language and look at the word. What's reliance damages?
I would argue that's what you were spending while you knew the contract was going to happen.
Right. In anticipation, I relied on it, that the contract would be performed as we had agreed, and on that basis, I have, in reliance on that, I've expended God knows how much. But since the contract now has been breached, I am out of pocket those monies, and I want to receive those funds back. So the fact is, those measures of damages are very different, as we're going to see at the back end of this case as well. Reliance really puts you back in the position you would have been prior to the contract being performed, where expectancy damages says that if, in fact, the contract had been performed as agreed, this is what you likely would have made. And we're going to see that there's a huge difference on this in the back end. And the last is 93A. And 93A prevents parties in Massachusetts, it's a Massachusetts statute, from being exposed to fraudulent and deceptive trade practices. And the beauty of 93A is that it will award double or treble damages, the actual damages, plus attorney's fees, which means this could be a huge, huge amount. Trial's bifurcated. Bifurcated trial means that you're going to try liability first, and then assuming you're able to establish liability, then you go into a damage phase. There's a bunch of different things going on. I think this whole top of page 464, you know, they tried to mediate it to some extent, and then Anthony tried to use that as saying, since the judge was involved in this, that the judge shouldn't have heard it, but the judge had heard the case. At any rate, I think they felt, the Supreme Court felt that that was really, really bad too. And really just seems like he's throwing anything against the wall to see what will stick. Deference to the judge's factual findings under 2. In a non-jury trial under Rule 52, we're going to see this later on, in a non-jury trial, the court is expected to make what we call findings of fact and conclusions of law under Rule 52. You, as the lawyer, will submit proposed findings of fact and conclusions of law under Rule 52. So it's with those findings of fact and conclusions of law that we can look at and determine how the judge arrived at their decision and make sure it's supported by the facts that they found and also valid under the law. So Rule 52 requires judges in non-jury trials to set forth those findings of fact and conclusions of law, and that what was done here. And what he's complaining about there is, well, the court pretty much adopted the findings of fact and conclusions of law by HBC. But as long as they're the product of their independent judgment, the fact that they use more from one side, virtually all from one side, that doesn't make it improper. There's arguments here about affirmative defenses, and as you see in that, you've got to plead them if you want to take the benefit of them. Is Anthony right or wrong when he says that under Massachusetts law, there is no covenant of good faith and fair dealing between sophisticated business people? That's what he said. Right? You read it, that's what he said. And the court said no. In every contract, there's a covenant of good faith and fair dealing. And they don't feel that what he did here was appropriate. This case does in fact find that what Anthony did was unfair and deceptive. That in fact, what the court made a mistake in not awarding 93A damages. It extends, as the case says, to both people engaged in a trade or business. And so it's going to regulate business v. consumer transactions as well as business v. business transactions. The case also uses the phrase rascality. When we're talking about a business-to-business 93A violation, they say that they're looking for a higher level of rascality than they might look for when it's business v. consumer. In subsequent years, the court really doesn't hold to that language of rascality, but it's been defined in the past as something that would raise the eyebrow of those inured to the rough and tumble business world. What we were talking about earlier is that you can't expect that business-to-business people are going to conduct themselves in the same way as we should expect a business person to conduct themselves with a consumer. They are out to do business. There is going to be a harsher environment, but the fact is that the court ultimately believes that this goes so far over the line that it violates 93A and becomes a fraudulent and deceptive trade practice. Look at the damages, and I want you to look at the damage issues that are listed here because it's the difference between expectancy and reliance damages. And so that's important to start to think about as you start to think about trying the case. I know you know the two definitions, but you want to make sure that as you start to think about your complaint, to think about your discovery, that you recognize that those standards, depending on the case, can be dramatically different. Here, the judge awards HBC $42.6 million in expectancy, or in the alternative, they could have $14.5 in reliance. And that's a difference, that's a huge difference. So if you were representing HBC, which would you take? Right? And they have the choice, assuming that you've offered evidence on both expectation and reliance damages, and you had pled in your complaint you were seeking restitution. This is not an insignificant issue, as you can see looking at those numbers, that you need to start to think about this when you're pleading your case. You know, damages, okay, it's time to make them whole, but which way will make me most whole? You know, would I be better off if the deal wasn't so hot as it turns out? I'd probably be better off with reliance damages. If the deal was good and I was supposed to make a lot of money, then expectancy damages will be better. And so then you've got to introduce proof on that issue, and that's what it says here. You also are entitled to interest, as the footnote at the bottom of that page talks about. It talks about on page 479, the aim in measuring damages in the event of a breach is to place the injured party in as good a position as he would have been had the contract been performed. And that's what we're looking at here when we look at these expectancy damages. They offered evidence of the value of the real estate by showing comparables. So we bring in experts to help prove that. That's what they did here. And that's how they ultimately were able to come up with how the damages are arrived at. I want you to look at 487 quickly. At the conclusion of the phase 1 trial of liability, that little gambit you tried there with putting the real estate into the trust, the judge issued an order enjoining Anthony's. Again, the court can issue injunctive relief, and that's what they did, from conveying, leasing, or otherwise alienating the fan care property. Just before phase 2 trial began, they wanted to raise the issue of the impropriety of the conveyance as well. And so all of that, I think, didn't place you in the best possible light. But at the end of the day, we've got damages at the minimum are likely to be 3 times those numbers I told you about, plus attorney's fees. So now Anthony has lost about 150, maybe $200 million as a result of what you've done. And he's not done suing people, right? No, really, let's be realistic. Because this should have been a conversation we had at the outset. Well, you said it would be bad. You didn't say it could be this bad. And it is this bad. This is not small money. So I hope you had that conversation with Anthony and told him it's a tough case. And I hope you reduce that to writing as well.
Win some, lose some.
Yeah, but it's important.
Well, win some, lose some. Most of us, and here's the epilogue to the story, most of us in this position would die broke and penniless and sad for our bad decision. Anthony, I told you, had very well-connected friends. Do you guys know the end of this? He sold half the real estate off to the federal government. His friend Joe Moakley helped bail him out, which is now called Moakley Courthouse on the waterfront. That's where that's where the federal courthouse now sits. The other half is just now finally starting to be developed. So he did get his money even
if he
after
does
this.
sue the attorney, how does the court look on that? Even if you did notify him in writing that you thought it was risky, or whatever words you used, and he still sues you, are they going to say, you know, well, you notified you, or are they going to take a close look at it and say, no, you really screwed up?
Oh, I think it's both. I don't think the letter simply absolves you from liability. Right. You know, in fact, you got to use what you got. I'm going to use the letter to say, you know, if I'm representing, well, you knew it was a bad case. In fact, so bad you sent him a letter, and you don't do this in every case, but you still filed suit, and you still charged him a couple $100,000 along the way.
It's evidence against you.
You use what you have, but I think it helps you to have told him, you know, because seriously, you should have told him this. I mean, this is not write a check for $1,000.
Right.
This is a couple $100 million back in the 80s. Right?
Yeah.
Right? This is bad. And the fact is, at the end of the day, you ought to have told them that. And I've seen this. I saw this more recently, a case I was involved in. They had a bad case. Told them they had a bad case. And when they lost, he then sues the lawyer because he says, "You should have told me how bad it was." Listen, I was on the other side. I told you how bad it was all along. Your own lawyer should have said, and I told him he should have said, I told him he should have told him how bad a case it was. But $150,000 later, he loses, and then he says, "You should have told me," to his lawyer. Well, should have known that anyway. But his lawyer should have been. Sometimes you guys have to be more vigilant, recognizing on the back end of this, it's going to blow up. And that's the promises at the outset is where you have to be careful. I worked with this lawyer. He would promise anything at the outset. And oh my God, it turned into so bad oftentimes before it was done. Because people will put a lot of money in thinking that they're going to get the result that you promised them. And when they don't, and when things get bad, then now you're taking all their money, you haven't delivered, and that's just going to be real. It's going to be terrible for you personally because you are going to get that report to the BDO. You can't overpromise, you can't oversell. You've got to be realistic. The problem that generates is that then sometimes they're going to shop and go somewhere else. Trust me, that's the best thing possible under the world because you're going to see other lawyers who oversell, but they're going to have they're going to have much more trouble at the end of the line. Let's do quickly Zapata versus Dairy Mart. Of course, I feel bad for everyone, but you don't feel bad for him either. They told him, "You have a choice. We have under the agreement the right to terminate the franchise. We're going to terminate it." They also told him, "Why don't you take that agreement to a lawyer for review?" He said no. They offered to repurchase his merchandise. Terms of the agreement said, we can terminate. If the contract says they can terminate, even though the poor guy is losing a business that he spent much of his life operating. Deal's a deal. Right? Is that about right? If you're a bad lawyer, but if you were representing Dairy Mart, kick his ass out in the street and take his stuff with you.
I mean, he did specifically say he didn't need a lawyer. He understood it. I mean, it sucks for him. It seems unconscionable that they can just close it down without cause and kick you out in 90 days. But I mean, the fact is that he
agreed to
got
it.
and they had proved it. You know?
It's like
Right?
at-will employment.
What?
It's like at-will employment, basically.
Yeah, it is, right? And the law can't protect you if you make a bad business deal here. And you both agreed they can terminate if they want. They're now terminating. There's nothing within the UCC or otherwise to protect him from his own bad business decisions. And that's really what this is. There's no showing that they acted in bad faith. There's no showing that they failed to observe reasonable commercial standards. You know what's interesting is in the back end of the case, 1379, note 14, the law of the Commonwealth recognizes that under some circumstances, a party to a contract is not free to terminate it according to its terms. And then they reference Fortune versus National Cash Register. Interesting that there are some times, but that was an employer situation. Here, our sympathies maybe with Mr. Zapata, but he's still out. See you next time.